Legal advocacy and access to justice is one of our fastest growing programs. It's something that we get a lot of questions about.
Sometimes our clients can be a little hesitant to reach out for legal services. Either they think, I can't afford it, I don't know that there are services that would actually provide what I need at the price point that's needed, or they've been disillusioned with the system, whatever that looks like, law enforcement, the legal system, which can be really challenging. So we really appreciate the partnership between our agency and both of your agencies. It's really important to have our clients understand, and we want them to continue reaching out for legal services so they can get the best response for their case. What you guys do is so needed. We get so many questions about it.
We want to remind our viewers that this is not legal advice. If you have questions, we want you to consult an attorney. Please reach out to us if you need help connecting with one. Thank you both for being here.
Thanks for having me. My name is Lisa Russell. I am a staff attorney over at Charleston Legal Access. I handle our partnership with My Sister's House. I do predominantly family law, domestic violence law, orders of protection, as well as guardian ad litem work. I do a lot of the safety planning and legal consultations for the My Sister's House clients, as well as full representation.
Great. Thanks, Lisa. Scott?
Thank you for having me. Also, Tosha. Scott McNeish, I'm an attorney with South Carolina Legal Services. We're a statewide law firm and we handle a number of civil matters. I'm the family law unit head, so predominantly I do practice family law. I do orders of protection, as well as divorces based on physical cruelty, adultery, any number, and dealing with child support, custody cases, alimony, you name the issue in the family court, I'm generally doing.
These questions, a lot of these come from our clients, so I'm excited to hear what these answers are. In what circumstances is it possible to terminate my abuser's parental rights, and how do I file for that?
Okay, so there are two instances in which one would terminate parental rights. One which is a voluntary, that generally takes place in preparation of an adoption or along with an adoption, in which case the parent who is terminating their rights signs a consent for relinquishment. That would be done in front of two witnesses, one of which would have to be an attorney not associated with that case. They review the consent with them, and a guardian ad litem is involved in that as well. Still, having done all that, it must go before the family court and has to be approved by a judge. So a judge has to still make a determination, ultimately, that it's in the child's best interest that rights be terminated. Which is why we see these generally take place in preparation for adoptions. You'll see these often in abuse and neglect cases through the Department of Social Services, where they will terminate parental rights. They will maintain custody of the child until such time as the adoption takes place in a private action, which will often be started very soon after or maybe running concurrently with the termination action. But again, it is an individual action in and of itself in the family court, just like one might file for divorce, there would be an action for the termination of parental rights. In conjunction with a custody case, normally in the event the termination was not granted, one would still be seeking custody of the child. There would need to be made a determination by the court. The other instance would be an involuntary relinquishment of rights, which also might be in an adoption case. So a parent or step-parent may wish, or grandparent may wish to adopt a child, but parents aren't willing to consent in the voluntary situation, and they would look to have that done on an involuntary basis. So slightly different. Still, a guardian ad litem must be done, must be appointed in the case to act on behalf of the child and indicate to the court or help the court with investigations what the child's best interests are. And then you have to prove, one, that some abuse has taken place. So a qualifying factor, perhaps the child hasn't been with the parent for 6 months, the parent hasn't paid support in 6 months. There was abuse and neglect in the case that rose to the level per the statutes. And then it is a heightened standard, actually. So it is a difficult case. So where we spoke previously about orders of protection or some of the other relief that might be granted in the family court, that is what's called a preponderance of the evidence. So a lower standard in the court. This is a clear and convincing standard, which would fall somewhere between what it would take to have somebody convicted and then what would normally be in the family court. So it is a heightened standard. Also, in the event that you have an indigent parent, they have the right by both case law and statute to have an attorney appointed for them. So if that parent does not wish to have the rights terminated, they can't afford counsel of their own, they will have an attorney appointed for them. So these are difficult cases to do, and barring there being something catastrophic or the abuse is the clearest indicator, obviously. Drug use, maybe a condition that they can't overcome, these are generally granted in adoptions. Standalone cases, they're difficult cases to undertake.
As far as the guardians are concerned, do those have to be appointed or requested by the court, or can an individual request a guardian?
Well, you can always request the guardian. In these cases, though, they are required by statute. So irrespective of request, they will be appointed.
In South Carolina, at what age is a child allowed to choose which parent they want to live with?
Again, this is a moving target. I will tell you that by statute, the court has to consider a child's preferences when making child custody determination. That's set out by statute. More weight is given, and this again comes through our case law, children 12 and above. But there's a lot of factors that go in that a court must consider. It's just one of them, and the amount of weight that's given. It's somewhat muddied in that it goes by the experience, the age, and maturity of that child. For instance, though 12 might be sort of the dividing line, there are some 12-year-olds that are considerably less mature than other 12-year-olds or 14-year-olds in the same ilk. And the court will take into consideration, was there any manipulation involved? In other words, has a child made this preference known based on a parent trying to convince them to do so? And again, a guardian ad litem is going to be involved in these cases. A child's preference, getting that before the court, is also something of its own. If you wish a child to testify, you're going to have to ask the court permission to do so. We have a family court rule that prevents children from testifying against their parents in contested matters. So the court will take into account, they may speak to that child independently, what we would call in camera. But generally that's done through the guardian ad litem, so those preferences will come out through a report done by the guardian ad litem in a final hearing.
So when you talk about determining the maturity of the child, is that something else that would also be determined maybe through the reports of the guardian?
Yes, it would be something done under the investigation, whether a guardian maybe placed more or less weight on those preferences.
Mm-hmm. Is there any consideration when they are trying to determine which GAL to place with a family around background, cultural sensitivity? How do they match up to make sure they're getting the right guardian to go with the family?
Well, in most cases, often if there's two attorneys involved, you can agree on the guardian, in which case your counsel can of course take that into consideration when suggesting guardians. There's only a limited number of people who do this work, so there's not a large list. So oftentimes, no, to answer your question, there's not a consideration placed by the court in that. It could very well be a list that they're taking, they have a list of guardians, or it could be their experience under the facts that they've seen at a temporary hearing or some other hearing that they believe a guardian who they've had appear in front of them would be right for the job. I believe judges do take that into consideration on a case-by-case determination, but not every time.
Mm-hmm. In cases of abuse, why are women and children usually displaced from the residence and the abuser gets to stay in the home?
As in anything with the family court, it really is a case-by-case determination. So some of these determinations are made based on the ability to pay for the home. If it's a piece of marital property, the courts wishes to have that maintained. If the woman in the relationship or the wife is unable to maintain it financially, then they're going to award it to the party who can. Now, if child support or there's an alimony award that enables them to do so, then they'll often stay in. Or when there's similar incomes and there can be a demonstration that you can afford to stay in the home, if it's the home where the children are, generally the parent who's been awarded custody of the children stay in that home. So it's generally, there is a bit of a math problem sometimes as to the ability to pay and maintain it.
It makes me want to jump back quickly to the order of protection, right? If I'm requesting in my order of protection that I get to reside in the home, if I am, say, a wife with 2 children and I don't work and I want to stay in the home, is there something in the order of protection where they can require the abuser or the husband in this case to continue paying?
Yeah, of
Yes.
course, they can. I think a judge is gonna have to make a determination at that time is the ability to pay. Are they gonna treat that as spousal support? In other words, may it be treated as temporary spousal support? And do they have the ability to pay that under the alimony laws in South Carolina and how that's viewed?
And it's important to note that if you want the court to consider those kinds of financial issues in an order of protection hearing, you have to give the court that information. So you're gonna need to file your financial declarations, produce financial information for the court to make the appropriate calculations. If you're asking for child support, run the child support guidelines. And so if that's something you want under an order of protection, it's always going to be an additional layer of information you'll need to present to the judge.
Thank you for bringing that up, Lisa. When we're thinking about the information that we have to present, that we have to bring to court, sometimes it can be a little overwhelming, right? Is there something either listed on one of your websites or another website that you would suggest our clients go and refer to so they can think about all of the things they need to bring with them ahead of time to court?
South Carolina Legal Services, we have a Level Up Law program, and through our website, you can reach those. We have our YouTube channel, and we have trainings on handling orders of protection, preparing for orders of protection. It's really helpful for us.
And another wonderful resource that I send a lot of people to is going to be the University of South Carolina's Domestic Violence Clinic website. I find that their walkthroughs are very I send them to South Carolina Legal Services and then also this website, but it's very user friendly and it's very directed at people who are not in the legal field 24/7, and so it gets down, both of those get down to some very fundamental, basic questions about going to court, especially, which is really helpful for women and anybody who's never actually had a ton of experience with the court system. I find a lot of people in these situations have their first experience was a parking ticket and that's about it. And so they've got some really fundamental questions. And so both of those resources are great places to start.
Thank you. Is there a law preventing my abuser's new partner or spouse from making parental decisions about my child?
No. There is not a law in South Carolina. However, there is the law of the case, meaning if you've been to court previously and you have a court order, there will be restrictions on what visitation looks like. And access to third parties is covered in that generally. If the overreaching question is, does South Carolina have a law as to such? No. But if you've been involved in litigation, there may be a restriction on access to paramours. In other words, somebody's dating. Can it be during the daytime? Can it be overnight? If you have those concerns and there are issues with a custody case, then those can be filed and addressed through the courts at that time. And the court is going to, now keep in mind the courts are inclined to, they want parents to visit with children. If there needs to be limitations on third parties' access, one must be able to demonstrate that that person is a danger to the child, or that their behaviors suggest as much. So, but no direct law is preventing it.
Can I use the findings or proceedings from my criminal court case to support my family court case?
Yes, as to findings. Proceedings, not necessarily. That will be a case-by-case determination. It will depend on the type of hearing that it is. Rules of evidence will control as to what amount of information regarding proceedings. Whether that is probative, in other words, does it help advance the case in any way, or is it prejudicial? It's just its inference in and of itself prejudicial to the court. But a finding is a finding in another court, especially a criminal proceeding, again, to get too into the weeds on it, but standards of proof. So because it's so much higher in the criminal courts, if you've been found guilty, that is a finding, that is a factual determination, it can be used in any other court.
Do I have the right to not sign a HIPAA form on myself and the packet from the guardian ad litem for my custody case?
So these sorts of things come about generally in a custody case. The court will be charged at the end of the day with determining what's in the best interest of that child. And based on whatever the allegations are within a case against both parties, there may be a need for, again, this is generally done with a guardian ad litem. So these HIPAA releases are not done so that opposing counsel can view. This is usually through a guardian ad litem, and there will be order issued, often in the temporary order or in an order specifically to appoint a guardian ad litem, supplemental order, in which case the judge will set out what, and one of the things that a guardian has rights to is information. And that may be school records, medical records, psychological evaluations, and the like. And to get that, some of the providers will require HIPAA. And if you're unwilling to sign it, the court may make you sign it. But it's often in the order that you'll sign it that is necessary for the guardian to get the information required.
So I think one of the concerns that we've heard from some of our clients is that, by signing, the opposing party or potentially their spouse would then have, access to all of their records for a certain time period.
And it's not an unrealistic concern. Anything that a guardian places in their file is discoverable. In other words, if you're in litigation, they can get copies of the guardian's file. In my experience, most guardians are sympathetic to this. They may not get a lot of the information. Some of the information they glean for their report may just be through conversations. It will not necessarily have to involve inspection of records. It may be. But if they do make copies or get copies of records, then yes, it may be discoverable. Which is again why if you have an attorney and the guardian requests something and they want a HIPAA, you may, through your attorney, maybe discuss with the guardian the breadth of that HIPAA release, and maybe everybody can agree to limit it to a degree.
If you get a guardian ad litem, typically how frequently throughout the week are you meeting with that person, or is that person potentially meeting with your children?
It's gonna, again, be on a very case-by-case basis. Initially, as the case starts, their initial appointment, it'll be with much more frequency. I tend to tell clients you should assume that your custody case will take you anywhere from 12 to 18 months to work its way through the court system. A lot of that has to do with things like investigations and the length of time, availability of the court. So if you need, for instance, if you need 5 days to be in front of the court, you may not have 5 days very often available, so therefore it takes a little bit longer. So these cases tend to, because they're so case specific, to take a long time. So early on, may be very active. As the case wears on, there may be less need. Things may settle down. There may be a status quo that's kind of created through a previous court order, and the guardian's interactions will be maybe just monthly to check in. Checking in on the parties, like want to go see the child at school, or as things occur in the case. So if there's something that you believe that your guardian needs to speak to a party, needs to see a child, at any time, either of the parties can reach out and have the guardian do that.
So if your case is expected to last potentially 12 to 18 months, you would also expect that guardian would be with you that whole length of time, is that right?
That's correct. Yeah, it's very rare that you would have a second guardian coming on the case. One guardian would be removed. It's a rare occurrence.
If I call and I'm looking for services, what sort of procedure should I expect is going to follow?
With South Carolina Legal Services, you can call the individual offices, like with my sister's house. Say we work with you guys, or we'll get a direct referral oftentimes. If you were calling in, you can go through South Carolina Legal Services .org, and you can apply online with us, or we have an 888 number one can call. I will say that 888 number does service 9 offices, 3 statewide organizations. So you may have to try a couple times, but an intake will be done. It will be directed to the office in the county in which that services the county in which you need assistance, and that will be given to an attorney. You'll speak to an attorney.
Charleston Legal Access, it's very similar. You can go to our website and complete the online intake form, and that will be sent to our intake manager, who then completes the first round of intake information. They will get your demographic information, contact information, and general overview of the situation. If we receive a direct referral from my sister's house, usually that will go direct to me, and then I will either direct it to a more appropriate legal service, or I will direct it to our intake manager and start that on our end. Once that has been completed, you will end up assigned to a staff attorney who will handle the legal part of the intake process. If any advice and counsel is warranted, give you a call, kind of talk to you about your options. However, we are not a statewide organization, so we do only serve the Tri-County area, so we only cover Berkeley, Dorchester, and Charleston.
My sister's house is really appreciative of the partnership that we have had and continue to have with both of your agencies. We can't do this work alone, so it's really nice to be able to have really well-qualified, I think, trauma-informed attorneys who understand what our clients are going through. To be able to advocate, education is so important. Certainly around what our victims are experiencing, what our clients are going through, and then being able to have attorneys who also understand what that cycle looks like, so you can explain it to other attorneys, so you can advocate the best way that you can in court for our clients. Thank you so much for the continued partnership. We look forward to seeing how we can expand our Access to Justice program in conjunction with Charleston Legal Access and South Carolina Legal Services. Thank you both so much for being here, Lisa and Scott. A wealth of information. We always appreciate you. And on behalf of our clients and our staff and our board, thank you so much.
Thank you.